Chapter 28. Rules of Pleading at Common Law. Some comparisons with the Code System. It is the purpose under this heading to state the principal rules of common law pleading, comparing them with those prevailing under the Code, so as to disclose the reasons for, and nature of, the changes made by the new system. The provision of the Code which made the most radical change, and about which there was the greatest complaint, will first be noticed. The petition must contain a statement of the facts constituting the cause of action, in ordinary and concise language, and without repetition. First, then, as to the common law form of statement which the foregoing provision of the Code sought to and did abolish, and second, the effect of the change and the nature of the new system which is introduced. Sec. 143. As to the common law and equity form of statement. The student of the history of procedure would first naturally desire to know what the form of statement prevailing under the old system was, in order to know and appreciate the reasons for any change. It is said that the form of statement under the old system was verbose, prolix, abstruse, technical and formal, while under the Code the facts are required to be stated in ordinary and concise language, without repetition. One only needs to take up one of the old works upon common law pleading, study the forms of pleadings therein found, and he will find useless and senseless formal statements which is far from being ordinary and concise language. The facts constituting a cause of action, it is true, should be the same now as under the common law, the difference only being in the way of stating them. There was a difference in the form of statement in equitable suits and actions at law. It is said that the rights of parties were frequently sacrificed in the common law courts to sustain technical and artificial rules and fictions, that the pleadings at common law were very much like the movements of an army before a battle, that the success of the parties did not depend so much upon the justice of their cause, as upon the sagacity of the pleaders in determining the point of attack and defense, and shaping the form of the issue, which was frequently prepared for the express purpose of avoiding the merits of the controversy. A speaker in address, J. Newton Fero, stated, abounding in technical forms at the outset, its rules with reference to parties, pleadings, trial and judgments became more and more arbitrary and artificial, and it revelled in subtle distinctions which arose and were elevated above and regarded as more important than the substance of the controversy. A departure from these rules was fatal to the suitor, regardless of the subject matter of the litigation. Lord Coleridge once said that the science of the system was deemed of more importance than the substance of right, and Judge Dillon pertinently remarked, the client's case oft times depended more upon the skill and ingenuity of his counsel than upon the justice of the cause. It is a mistake to suppose that the common law practice was the result of careful, scientific examination and analysis, and that it was adopted full-fledged by the courts as the most convenient and best method for accomplishing the ends in view. On the other hand, it was entirely a growth by way of evolution from ancient methods, passing through successive stages which we have suggested, and coming to its present condition by the survival of the fittest, and evolution which is still in progress and very far from completion. Sir Matthew Hale said that, the science of pleading has departed from its primitive simplicity, of which the length of the pleading, the many and unnecessary repetitions, the many miscarriages of causes on small and trivial niceties in pleading, have too much witness. The form of the statement of the cause of action, and the issue to be made thereon, depended in common law pleading, not so much upon the facts constituting the cause of action, or the relief sought, as upon the kind of action instituted. The facts constituting the cause of action were required to be stated according to the form of the action brought. Pleading at common law was pursued according to two methods, one called special pleading, and the other general pleading. It is necessary to understand these two modes of pleading in order to appreciate the change. And it is also well that one should thoroughly appreciate the spirit of the Code, and the evils of the former system of pleading, so as to avoid complications and abuses in the new system akin to those which prevailed in the common law. The manner of pleading according to those two methods, almost utterly failed to accomplish the primary objects of pleading, namely, to present the facts in dispute to enable the court to pronounce the law in such a manner as to readily disclose the points at issue. A criticism of the common law system of pleading was that the lawyers themselves were responsible for its degenerated condition brought about by their abuses. Sec. 144 Code System of Fact System. It is well understood that we designate the code system of pleading as a fact system in contrast with the common law, and it was about this matter that all the useless and senseless controversy was heard among the lawyers at the time of the adoption of the code. There was in fact no change but one of form. It took precisely the same facts to constitute a cause of action under the code, as it did at common law, but we do not want the code action stated in technical formal language, nor do we want duplicate statements, or statements of legal conclusions, or of the legal effect of instruments, but simply the ultimate or operative facts, and let the court say what the law is upon them. The word fact meant exactly the same before as after the code. The word facts had obtained at the enactment of the code a specific and well-defined meaning. One of the first principles of pleading is, that it is only necessary to state the facts, and in alleging the facts it is necessary to state such circumstances as merely tend to prove their truth. The facts constituting a cause of action or the defense, must be stated, and it requires the same facts to constitute a cause of action or defense, as before the adoption of the code. Whatever facts were essential and material before the code, to give a party a cause of action, or to constitute a ground of defense are still essential and material, and must be stated in the pleading. The same test applies. Some of the most salient and defective features of the common law system may now be noted. Sec. 145. Legal conclusions. Under the common law, conclusions were frequently pleaded, and under that plan a pretended cause of action could be stated by the pleader which would fit his own notions, because it would be a statement of his own conclusions drawn from the real facts in the case. It was, therefore, reasonable to require the facts themselves to be pleaded, and not what the pleader claims follows as a legal conclusion. You should not say, for instance, that a thing was duly or lawfully done, without stating the facts showing that it was lawfully done. It may not have been lawfully done, it is the fact and not the conclusion that is desired. It is clear that, both at common law and under the code, the statement of a mere abstract proposition of law, involving in it no allegation of fact, constitutes no part of a cause of action or defense. It is mere surplusage. While writers upon procedure under both the common law and the code, say that it was not proper to plead legal conclusions under either system, still such was not the practice altogether at common law, as pleading by means of the common counts in assumpsit and the general issues, was clearly the pleading of legal conclusions. This form of pleading was wholly inconsistent with correct principles of pleading, and was a departure from the true rules prevailing under the common law. But nevertheless the practice grew up of pleading the legal effect at common law. Says Chitty, it is laid down as a principle that a contract or written instrument should be stated according to its legal effect. This rule is of very extensive operation, and applies not only to the statement of contracts in the action of assumpsit, but also to the statement by either party of contracts and obligations of every description, whether verbal, written, or specialty. In any form of action, the party is not compelled to follow the precise form of words in which the contract was made. It suffices if he state its true legal effect and operation, and it has been observed that a deed may be declared upon, without using a word which was contained therein, except the name of the parties and the sums. Indeed, in some cases it has been held proper, and indeed absolutely necessary, to depart from the terms of the contract, and a party has been defeated on the ground of variance, when he has used the precise words of the contract, but misstated its legal operation. The effect of the code was that the material facts should be averred as they actually existed or took place, and so in pleading the facts of a cause the court wants either the precise words, or the substance thereof without any coloring on the part of the pleader. The theory of this rule is at once apparent and sound. It is not for the pleader to put forth in the slightest degree what he conceives to be the legal conclusion of facts, but that he should state the facts exactly as they are, and let the court say upon the fact of the pleadings, if tested by admirer, whether the law would give him a right of action. This is but just. It may be that if he states the real and actual facts, that the law would not give a remedy, and he would thus get into court and cause his adversary unnecessary trouble in the trial. At common law they considered the dangers resulting from misrecitals and literal mistakes greater than those resulting from a mistake in the legal effect. This is, strictly speaking, one of the principal points of distinction between common law and code pleading. In nearly all of the various common law actions the actual facts were not stated, but legal fictions, or the legal effect of facts and of written instruments instead. It is claimed for the common law system by some of the text writers, that system demanded the statement of the facts, but an examination into the allegations which were made, will not justify the statement. In Beaton trespass and case the facts were more nearly stated. But in all the cases it was the privilege of the pleader to state only what he considered in his own opinion, and what he deemed best suited to his claim, to wit, the legal effect of facts. The legal effect of facts are not exactly the bare conclusions of law, but are combinations of fact and law. Allegations of inferences of law were sometimes made at common law for the purpose of showing the intended and logical application of the facts pleaded. There are instances where it is said that the facts and the legal effect thereof are so blended together that the facts cannot be stated without in a measure stating their legal effect, and in such cases it is considered to be proper to so state them. Judge Swan's treatment of this matter in his pleading under the Code is pertinent to this discussion. He says, an allegation of the legal effect of a fact, is a statement of the legal inference or conclusion of law upon such fact. The statement of this legal inference may be a statement of the fact itself, more or less definite and certain. Under the rules of special pleading at common law, sometimes facts and their legal effect are substantially identical, sometimes the averment of legal inference is a mere statement of the conclusion of the fact from other facts, and sometimes the legal inference is so artificial and illogical, that its statement conveys no intimation of the fact from which it is inferred, and belongs to the fictions of common law pleading. An allegation of what, at common law is termed the legal effect of facts, is generally the ordinary language in which intelligent men state facts. The statement of a fact in ordinary language, embraces facts, sometimes necessarily and clearly, sometimes indefinitely, implied. The English language, even when used in a more definite, certain and precise manner than ordinarily, is imperfect in this respect, and leaves something to be implied. The Code, however, in requiring statements in ordinary language, demands of courts to construe them, and to hold them to embrace, impliedly, in pleadings, all that the language embraces when used elsewhere. This is a fundamental and governing rule. The question, therefore, whether an allegation is a statement of a conclusion of law or fact, has nothing to do with the sufficiency of code pleadings, inasmuch as facts must be held to be implied from, and therefore embraced in, the allegations of code pleading, precisely to the same extent as like language implies and embraces facts, when ordinarily used by intelligent men in the statement of facts. If, when thus construed, the precise nature of the charge or defense is not apparent, the opposite party may be relieved from the uncertainty, by motion, compelling an amendment. The general rule, therefore, in respect to what has been denominated allegations of conclusions of law, and which consist only of a statement of the legal effect of facts, seems to be this: if they amount to a mere abstract proposition of law, having no element of fact, they form no part of the allegations constituting a cause of action or defense, but if they contain the elements, also, of a fact, construing the language by its ordinary meaning, then force and effect must be given to them as allegations of fact. But if they are so uncertain, indefinite or inferential, that the precise nature of the charge or defense is not apparent, the court, on motion, will require the pleading, in this respect, to be made more definite and certain by amendment. Undoubtedly, the correct mode of pleading under the Code is, in general, to set forth, not the inferences, or the propositions of law, which may be derived from the facts which constitute the cause of action, but the facts themselves which are capable of being ultimately established, by direct or circumstantial, oral or documentary evidence. But there are many cases in which it is proper and more concise, to state simply the legal effect of a fact, as in the illustration already given, when necessaries are furnished to an infant, or when a deed or mortgage is alleged to have been made, or the ownership of property is averred. In these, and many other cases, the legal effect of a fact is the proper mode of allegation under the Code, as it was in common law. So much for the subject of legal conclusions. We have given the common law and the Code rules upon the subject. The two kinds of pleading which prevailed at common law will next be considered. 1. Special pleading, or pleading by special counts or pleas. 2. General pleading, pleading by common counts and general issues. The object of pleading has always been to present the facts in such a manner that the points in dispute, to which the proof is to be directed, shall be readily perceived. Not one of these objects was gained by these two modes of pleading. Sec. 146. Special pleading explained. There is not much to be found upon the subject of special pleading in the books. It was the fact system in contrast with general pleading. It consisted in stating the facts constituting the cause of action with such verbosity, formality, falsehood and fiction, as to conceal and render the issues obscure. Court and jury, adroit word spinners, vied with each other in their efforts in this direction. The fault then was not with the system itself, but arose from the habits of the people and the times. Say the Code Commissioners, by reason of the arbitrary and technical rules applied to it, it so abounds in verbiage, formality, falsehood, and fiction, as oftentimes to conceal the facts from the court, the jury and the parties. In Stephen on Pleading, page 148, we are told, when special pleading was invented, the Republic of Letters was an oligarchy. The few who possessed any portion of its wealth or power, were inclined to waste them, upon matters of more show than use. At the same time the intellectual poverty of the multitude, rendered it necessary to reduce to great simplicity the questions which were submitted to their decision. To these causes are to be attributed the formality and complexity which in our time constitute popular and valid objections to that system. Apostrophe whether the author of this sentence be right or wrong, in giving the causes which originated such a system, we do not think the system should outlive them. Take a special pleading in any of the actions, and we are compelled to admit that it is an obscure and unsatisfactory method of stating facts. So unfit and objectionable has it been found, that in instances almost numberless, the legislature and the courts have departed from it and gone to the other extreme. Our statute books abound in provisions intended to obviate the embarrassments and imperfections of the rules of special pleading, and it is interesting in this connection, to notice the many cases in which they provide that the parties need not plead specially, and may plead generally, as if to obviate the objections to the prolixity and abstruseness of special pleading. General pleading was introduced, which is next explained. Sec. 147. General pleading explained. General pleading was a form of pleading inaugurated to obviate the objection to special pleading, and consisted in the formation of short, terse forms of allegation for various actions, which wholly failed to state the facts. The Code Commissioners said of it, the system, as we have said, is the extreme of the other, and is the work of courts and legislatures, in their attempt to get away from it. A more entire emancipation from all the rules of pleading could scarcely be desired. This kind of pleading discloses nothing to the court, to the jury, or to the parties. The former kind, special pleading, abounding in verbiage, subtlety and abstruseness, often conceals the facts in special and technical allegations, while this, remarkable for brevity, does not state them at all. It has proved the more acceptable and popular method, and has gained steadily on special pleading. To remove the objection that it disclosed nothing, and to ascertain the matters in dispute, we have resorted to something else than pleading, and required the plaintiff to furnish a bill of particulars of his claim, and the defendant to give some notice under the general issue, of the defense he intends to make. The nature of the common counts in a sumpsit and of the general issue in the various actions, which constituted what is termed general pleading, have heretofore been explained. If a lawyer were to undertake to get before the jury the issues involved in a case where general pleading had been adopted by reading the pleadings, without explanation or comment, neither the court nor jury would be able to tell what they were. Sec. 148. Change to fact system discussed. It was principally the objections to this form of pleading, and to the particular forms of statement which had to be pursued in the different forms of action, the arbitrary forms of action, the harsh rules relating to the joinder of actions, and the separation of law and equity which led to the adoption of the Code of Civil Procedure. And what did we get in lieu of the old system? All these matters have been explained so far as concerns the displacement of the common law by the Code, excepting as to the form of statement. And now, after having run over the principal features of the common law system of stating a cause of action, we will discuss the provision of the Code which wrought the change quoted in the beginning of this subject, to wit, that the cause of action must be stated in ordinary and concise language, without repetition, after which reference will be made to some other lesser important common law rules of pleading. Sec. 149. Statement of facts in ordinary and concise language. It was intended by the framers of the Code to adopt a system which would be a medium between the old form or manner of statement. It is denominated the fact system. The Code Commissioners said, "We do not aim to make pleadings a system of dialectics, or to lay the foundation for a new and cunning science of disputation. On the contrary, the aim is to avoid such a result and confine pleading within its proper bounds, making it a mere auxiliary in the administration of justice, never defeating it. We would not allow it to impede the cause of justice by deciding causes, not upon their merits, but by its rules, which are sometimes only ceremonial. The kind of language which the Code contemplates or requires shall be used in pleading is such as intelligent, educated men use, not technical and artificial. Language used in a pleading is to be considered in precisely the same light as it is when used by plain, sensible people in the common affairs of life. It is construed by courts exactly in the same manner as it is used and understood by intelligent men. It is not hypercritical, nor do they indulge in a mere verbal criticism of words. There can be no doubt but that it takes precisely the same facts now, as formerly, to constitute a cause of action in a sumpsit, in conversion, in trespass, or case, the only difference being, that it is necessary to state them concisely, without repetition, instead of verbosely and prolixly. Simeon Nash, author of Nash's Pleading, not a very good friend of the Code, speaking of ordinary and concise language, said, "What these words mean, it is somewhat difficult to say. If they mean that the facts shall be stated in appropriate language, then they are useless, because facts must always have been so stated. The science of law, like all other sciences, has its fixed and well-defined nomenclature, and facts, when stated in this legal language, were always well stated, so stated that every lawyer knew the exact import of the statement. But, if by ordinary language is meant the language of common life, then the clause is absurd, because the language of ordinary life is not conversant with such subjects, and hence has no appropriate language in which to embody such facts. Ordinary men invariably state the evidence by which facts in legal contemplation are to be proved, and not the facts themselves. These words can have no legal operation on the balance of the section. By it the facts constituting the cause of action are to be stated, and nothing more, and certainly nothing less. This writer also finds apparent difficulty resulting in the unison of law and equity so far as concerns the statement of the facts constituting the cause of action. He seems to think that the Code provision which we are discussing cannot be applied to two different classes of rights, arising under two distinct systems of law and two distinct systems of relief. Are the facts in both classes of cases to be stated alike, or are they to be severally stated, according to the respective natures of the two different systems of law, and the two different systems of relief? He asks. He well states that the manner in which the facts shall be stated will depend upon the nature of the facts themselves, and the kind of judgment he seeks to obtain. A case, therefore, predicted upon the principles of equity cannot be stated like a case founded on a promissory note, a bond, or a covenant, or an injury arising from torts. Legal and equitable proceeding are essentially different from each other in their origin, nature and object. In a common law action, the plaintiff presents an absolute right to relief, in the most concise and expressive language. He states his title, and nothing more. But in a suit in equity, none of this rigid logic prevails. An equitable claim may be composed of numerous independent facts, all of which, or only a portion, may be required to satisfy the court. A legal claim is a single proposition, which must stand in all its parts or fall. The one is a chain which is worthless if a single link fail, the other a rope, composed of numerous strands, some of which may give way, and yet enough remain to secure some relief. No fault can be found with that kind of argument, because it is well understood that the intrinsic nature of facts constituting a cause of action in equity, must of necessity be materially different from those constituting a cause of action in law, but that makes no difference in stating them in the petition, because either may be stated in accordance with the rule prescribed by the Code. Sec. 150. Are any common law rules of pleading in force under the Code? Section 83 of the Ohio Code as originally adopted read, "The rules of pleading, heretofore existing in civil actions, are abolished, and hereafter the forms of pleading in civil actions in courts of record, and the rules by which their sufficiency may be determined, are those prescribed by this chapter." The first part of that section, to wit, "The rules of pleading heretofore existing in civil actions, are abolished," was dropped, leaving the Code now standing. The forms of pleading in civil actions in courts of record and the rules by which their sufficiency shall be determined, are those prescribed in this chapter. The question which arises under this provision is, whether or not the former rules of pleading are now in force, or whether the Code is the only source of authority. There is one fact which all must concede, and that is, that the Code does not prescribe all of the rules which we now follow in our system of pleading. The rules governing the matter of alleging facts showing privity, or of anticipating a defense, or of alleging consideration, or damages, or contracts required by statute of frauds to be in writing, or matter falling within statutes of limitations, are not prescribed by the Code. Professor Pomeroy says that it may now be regarded as the established doctrine that the Code in each of the states is the only source of authority from which rules of pleading may be drawn, that its methods have completely supplanted those which precede it, so that the latter can no longer be appealed to as possessing of themselves any force and authority. Judge Swan has taken the same view, both as an author and a judge. In Trustees v. Odlin, 8 S. 293, he says that, whatever rules of common law pleading are in accordance with the rules of the Code, they are still applicable to pleadings under the Code, not, however, as common law rules, but as rules of the Code. Thus the rules of common law pleading which illustrate and vindicate the law that the facts which constitute a cause of action shall be set forth in the declaration, may be applicable to a petition under the Code. But the language to be used in stating the cause of action is prescribed by the Code, and the common law rules in that respect are entirely inapplicable. This is not entirely true. There is no general provision in any of the codes making the common law rules applicable, and they have been applied by courts just as other common law doctrines have been applied. But very few rules of pleading have been prescribed by the Code. The great bulk of the common law rules as found in Stephen being now the rules followed under the Code. Swan further says, the principles of every system of pleading depend, in practice, whatever it may be in general theory, upon the rules which it prescribes for setting forth a cause of action and a defense, the manner in which the pleading shall be made up. These rules are different in different systems, and the common law system does not, under the Code, remain unchanged any more than the system of equity pleading remains unchanged by the Code. This idea of subordinating the Code system to any other system, is in every way, mischievous. The Code abolishes the common law system. The Code rules of pleading indicate the principles pleading is just as operative in Ohio as the common law system. The Code rules of pleading indicate the principles upon which they are founded. They stand upon their own inherent force, and are neither to be enlarged or limited by the Chinese or common law system. The remaining rules of pleading prevailing at common law are now substantially enforced under the Code and will be touched upon in going over that subject, but some of them will be briefly considered here. Sec. 151. Rule against duplicity. It has always been a fundamental principle of pleading that the facts should be presented in as simple a form as possible. Duplicity was the vice of stating two or more grounds for the support of a single claim or defense. It was necessary that a party having several grounds of recovery should make a selection upon which he would stand. The defect of duplicity in pleading was formal, and was reached at common law by a special demurrer. The rule against duplicity was enforced with great severity, and there came into use a mode of setting forth the same cause of action in different ways of separate counts, shaping each differently, stating the cause of action variously as to some of its facts and circumstances, so that if the proofs failed to sustain one form of statement they might support another of the counts, or one count might be good in law when the others were insufficient. In some cases the facts relied upon might be different, as in case of different breaches of the same penal bond. This practice became universal in declarations in Exposition and gave rise to the common counts. Under the code the rule against doubleness or duplicity is not inflexible, it being permissible in rare instances where the facts are within the knowledge of the adversary, and the complainant is not in a position to positively and definitely know the true ground of his action, in which event the pleader may in a proper form plead his cause in two or more counts or in different form as though it constituted more than one cause. The facts and circumstances must be such as to appeal to the justice of the court, because if any rule is well settled in procedure it is that a cause of action must be founded upon one definite theory, which is the criterion for subsequent pleadings. The rule condemning duplicity means that the petition, complaint, or common law declaration must not, in support of a single demand, allege several distinct matters, or several distinct grounds each founded upon different theories, by any one of which the demand may be supported. At common law this rule applied to the declaration, and all subsequent pleadings, none of which should contain several distinct answers to that which preceded it, the reason of the rule in each case being that such pleading tends to several issues in respect to a single claim. Id. The object of the rule being to enforce a single issue upon a single issue of claim admitting of several issues, is accordingly carried no farther than this in its application. It does not prevent a complainant from alleging as many distinct matters as may respectively support several demands. The only difficulty lies in the application of the rule in determining what facts or how many facts will constitute a single cause of action. Dr. Stephen said, "No matters, however multifarious, will operate to make a pleading double, that together constitute but one connected proposition or entire point." According to certain modes of practice in England, the rule against duplicity in pleading was materially qualified and evaded. In common law practice as under the code, a complainant had the right to join in one declaration as many distinct and separate demands as could be the subject of one original writ, as where several distinct trespasses had been committed, all could be joined in one written declaration. The joining of such distinct causes in one declaration constituted different parts or sections of the declaration, which became known in the parlance of pleading as several counts. This practice did not violate the rule against doubleness in pleading, but on the contrary the use of several counts, when applied to distinct causes of action, was consistent with the rule against duplicity. It was proper to resort to several counts for the purpose of setting forth several distinct causes which could be joined in the same declaration, which was consistent with the rule against duplicity. But, as Stephen said, it happens more frequently than otherwise that, when various counts are introduced, they do not really relate to distinct claims, but are adopted merely as so many different forms of propounding the same cause of action, and are, therefore, a mere evasion of the rule against duplicity. This is a relaxation of very ancient date, and has long since passed, by continual sufferance, into allowable and regular practice. It takes place when the pleader, in drawing the declaration or bill in any action, or in preparing the precept for an original writ of trespass, or in trespass on the case, after having set forth his case in one view, feels doubtful whether, as so stated, it may not be insufficient in point of law, or incapable of proof in point of fact, and at the same time perceives another mode of statement by which the apprehended difficulty may probably be avoided. Not choosing to rely upon either view of the case exclusively, he takes the course of adopting both, and accordingly inserts the second form of statement in the shape of a second count, in the same manner as if he were proceeding for a separate cause of action. If, upon the same principle, he wishes to vary still further the method of allegation, he may find it necessary to add many other succeeding counts besides the second, and thus in practice, a great variety of counts often occurs in respect of the same cause of action, the law not having set any limits to the discretion of the pleader, in this respect, if fairly and rationally exercised. But it more frequently happens that it is the same state of facts differently represented which forms the subject of different counts. Thus, where a man has ordered goods of another, and an action is brought against him for the price, the circumstances may be conceived to be such as to raise a doubt whether the transaction ought to be described as one of goods sold and delivered, or of work and labor done, and, in this case, there would be two counts, setting forth the claim both ways, in order to secure a verdict, at all events, upon one of them. And it may be useful to observe here that, upon this principle, the counts for money lent and advanced, money paid, money had and received, and money due on account stated, are, some or all of them, generally inserted as a matter of course, in every precipe, declaration, or bill in a sumpsit, though the cause of action be also stated in a more special form in other counts. It is to be observed, that whether the subjects of several counts be really distinct or identical, they must always purport to be founded on distinct causes of action, and not to refer to the same matter, and this is effected by the insertion of such words as other, the further sum, etc. This is evidently rendered necessary by the rule against duplicity, which, though evaded, as to the declaration, by the use of several counts, in the manner here described, is not to be directly violated. The practice with reference to the use of several counts by the complainant in the declaration, was sanctioned by the courts, while the rule of practice which permitted a defendant to set forth several pleas is grounded on the statute of 4 Ann. C. 16, which provided that it shall be lawful for any defendant or tenant, in any action or suit, or for any plaintiff in repline, in any court of record, with leave of the court, to plead as many several matters thereto as he shall think necessary for his defence. The defendant was thus permitted to plead several distinct answers or defences to the same claim or complaint. The practice was relaxed so that a defendant could not only plead several pleas to the same count, but the defendant under colour of pleading distinct matters of defence, was permitted to state variously, in various pleas, the same defence, this being done by presenting it in an entirely new view, or by omitting in one plea some circumstances alleged in another. As the defendant had to obtain leave of court, some restraint was exercised by refusing the pleas where the proposed subjects of the plea appeared to be inconsistent. For example, leave would be refused where the plea to trespass would be not guilty and accord and satisfaction, or non est factum and payment to the same demand. But the more modern settled practice permitted such pleas notwithstanding the inconsistency or repugnancy. The power of pleading several matters extended only to pleas in bar, and not to dilatory pleas. Id. 266. Sec. 152. Same verification of pleadings. The common law did not require pleadings to be verified. They could not consistently be verified because there was so much fiction and falsehood in the statement of the cause of action. One object in requiring pleadings to be verified was to abridge and shorten them. If a party has but one cause of action, or one ground of defense, he can make but one plain statement of the facts. He cannot swear to contradictory statements in the same pleading. The evils of the common law which this rule as to verification aims to dispense with, were the great length of declarations, and the great number of pleas. It was common practice under the common law for a plaintiff having but a single cause of action, to make 3 or 4 different statements or counts in the declaration, which might be met by several pleas by the defendant. To illustrate the common practice on this subject, suppose the plaintiff to have a single claim founded on a common assigned due bill. The declaration would often contain one count alleging the money to be payable on the day of the date of the due bill, and another, that it was payable on demand. But lest these might not give a proper description of the due bill, another count, including all the common counts, would be added, alleging in substance that the defendant was indebted to the plaintiff for work and labor, and materials found, for goods, wares, and merchandise sold and delivered, for money paid, laid out and expended for the defendant, that they had accounted together and a balance was found due to the plaintiff, which the defendant had faithfully promised to pay. The attorney for the defendant, looking at such a declaration, could have no idea of the real nature of the plaintiff's claim, but in order to meet any state of evidence which might exist in favor of his client, he would plead 1. That the defendant never gave such a due bill, 2. The statute of limitations to the common counts, and 3. Give notice of set-off, and the plaintiff was indebted to the defendant for work and labor, and for all the other causes of action included in the common counts, and claim judgment for a balance. It may be that in years gone by there had been dealings between the same parties, which had been settled long before the due bill was given or assigned to the plaintiff. The defendant knows, from the claim in the declaration, that the defendant may prove the items on his side of the old accounts, and unless the defendant is able to prove the items on the other side, the plaintiff might recover his account over again. The plaintiff also knows, from the claim of set-off, that the defendant might do the same thing, and they both thereupon prepare their evidence, and it becomes necessary that the old account should be investigated. To avoid all this prolixity of pleading and expense of trial, the codes require that the plaintiff's petition shall contain a single count, stating that the defendant is indebted to the plaintiff in a certain amount on the due bill annexed to the petition, and attach his affidavit that he believes the facts stated in that single count are true. He knows that the defendant owes him for nothing else. The defendant then sees the precise claim of the plaintiff, and he knows he did execute the due bill, that the old account was settled, and that the due bill remains unpaid. What plea can he file in the case? He cannot and he will not swear to a plea of payment, or that he has a set-off against the plaintiff, or that he never executed the due bill, for he knows that neither of these defenses are true, and therefore, without plea, without witnesses and without trial, he allows a default to be taken. The court calculates the interest and renders judgment. The whole record is composed of perhaps 20 lines instead of many pages. Similar cases to the one here represented have often occurred. To require a party to make affidavit to the truth of his statement, not only abridges the pleadings, but also it would often dispense with proof, litigation and costs. No man ought to be allowed to file in a court of justice, as true, a pleading which he either knows to be false, on which he does not believe to be true. No man should be sued for an unjust claim. No just claim should be resisted by a false defense. The time of courts, witnesses and parties, should not be occupied in such litigation. All these evils are, to a great extent, prevented by requiring the party to make oath that he believes the facts stated in his pleading to be true. The principle was not new. Such affidavit had always been required to pleas in abatement, to bills in chancery, asking injunctions, to answers in chancery and to numerous proceedings in court. The Code Commissioners said, if the party be not confined in his pleading to what he believes to be true, no adequate reform in pleading can be effected. We think, if pleadings are required to be verified, although the same number of suits should be brought, not half the number of witnesses will be necessary, which have heretofore been used in trials. It would not deter an honest man from making a just claim or defense. All such claims and defenses should be encouraged. Certainly to encourage all rightful litigation, and check the wrongful, opening wide the doors of courts to honest suitors, and as far as possible, to them alone, and favoring only the resistance to unjust demands, must ever be the great object of the lawgiver. The verification of pleadings would in our opinion go far towards 1. Preventing unjust claims, 2. Shortening pleadings, 3. Dispensing with witnesses, 4. Shortening the time occupied in trials, and 5. Saving costs to parties. It was recommended by the New York Commissioners, and partially adopted by the legislature of that state. Has been adopted in Kentucky and Missouri and had proved useful in abridging pleadings and shortening trials. Sec. 153. Pleadings were required to have certainty of place. It was necessary at common law that the declaration should lay a venue, that is, it was necessary to allege the place where the facts constituting his cause of action arose, so that the jury could be summoned from that vicinity. There was a division of actions at common law into local and transitory. Local actions related solely to land and were tried where the same was situated. Transitory actions related to something purely personal between the parties, as a debt or duty which would follow the person wherever he may go. Transitory actions could be tried wherever the defendants could be found and served with process, it being necessary to allege in the declaration that the facts occurred at the place where the venue was laid. The following comments were made by the Code Commissioners upon the sections relating to venue. This title states the law of venue about as it is in this state. Some actions are local, and should be so for obvious reasons. The difficulty occasioned by making them local, is greatly obviated by allowing process in such cases, to be issued to any county in the state. We believe we make none local that are not so now. The provisions in relation to actions against corporations are very similar to those we now have. The general provision is, where the action is not local, that a domestic corporation should be sued in the county where it is located, or has its principal office, or place of business, but exceptions are made in the cases of insurance, railroad and turnpike companies. These exceptions are in accordance with existing statutes. So also is the section relating to actions against foreign corporations. The great body of the actions are transitory, and the defendant must be sued in the county of his residence. This very proper requirement we derive from our present practice. Sec. 154. Pleadings were required to have certainty of time. In personal actions at common law it was necessary to allege the precise time when all traversable facts occurred. The true time was not always alleged. When parties did not want to prove it strictly, it could be laid under a vid illicit, that is, by preceding it by the words, to wit, or that is to say. It was considered necessary whenever venue was laid to also allege the time. The common law doctrine being that the necessity of averring time extending only to traversable facts, it followed that no time had to be alleged to matter of inducement or aggravation. There were then, as now, instances in which time formed a material point in the merits of the case, in which event when a traverse was laid it was of the substance of the issue, and had to be strictly proved. It was therefore necessary in such instances to state the time truly, at the peril as for a variance. Certainty of time is said to be required in personal actions only, it being held that in real and mixed actions it is, in general not necessary to allege the day, month and year, and that it is sufficient to state in what king's reign the matter arose. Stephen P. L. p. 386. It is only necessary to allege time and place in code practice when it is material to the issue. Sec. 155. Pleadings must show quality, quantity and value. In declaring for injuries to goods and chattels, or upon any contract relating to them, it was necessary to state their quality, quantity and value or price. And in any action brought for the recovery of real property it was necessary that its quality be shown, as whether it consists of houses, lands or other hereditaments. It was also essential that the quantity of lands or other real estate be specified. In actions brought for injuries to real property, the quality had to be shown, as whether it consists of houses, lands or other hereditaments. So now in stating a cause for corporal injury to realty, it would be necessary to give a full description of the injury, which would render it essential to show quality. The rule was not followed so strictly that it did not admit the specification of quality and quantity in a loose and general way. It was sufficient to declare in trespass for breaking and entering a house, damaging the goods and chattels, and wrenching and forcing open the doors, without specifying the goods and chattels, or the number of doors forced open, for that the essential matter of the action was the breaking and entering of the house, and the rest merely aggravation. And Steph. P. L. 388, in actions of debt and assumpsit for goods sold and delivered the quality, quantity or value was never specified. When quantity and value were alleged and thus brought into issue, it was not deemed necessary that the proof should correspond with the averment. The pleader, under a vid illicit, could lay any value he pleased without risk of variance in the event of a different amount being proved. But a verdict could not be obtained for a larger quantity value than is alleged. So now, no recovery may be had for a greater value than is alleged, if that be the amount of money prayed for. It was possible in certain instances, however, where quantity and value was of the substance of the issue, in which case it was essential to prove it as laid. With respect to the allegation of quality, this generally had to be proved as laid. Sec. 156. Names of persons had to be specified in the pleadings. It was necessary that both the original writ and the declaration set forth accurately the names of the parties, describing the plaintiff and the defendant by their Christian name and surname. A mistake in the name of a party to a suit was considered ground for plea in abatement only. At common law, as under the Code, if the names were not known, that fact had to be alleged. Sec. 157. Pleadings must show title. When in pleading, any right or authority is set up in respect of property, personal or real, Some title to that property must of course be alleged in the party, or in some other person from whom he derives his authority. Title by possession was all that was necessary in some cases, and in others full title had to be alleged. Title in fee simple was that the party was seized in his domain as of fee. In some cases derivation of the title had to be shown, that is, it had to be shown in the pleading how the title came to the person claiming it. The rules of pleading concerning this matter in England depended of course upon the character of the title if real estate was involved. If the action related to corporeal hereditaments, the form was to allege that the close, etc., was the close of the plaintiff, or that he was lawfully possessed of a certain close, which was a conclusion. Where a title of possession was alleged in respect of corporeal or incorporeal hereditaments, it was sufficiently proven by any kind of estate in possession, whether in fee simple, fee tail, for life, for term of years or otherwise. A title by possession was not sustainable by proof of an interest in reversion or remainder. Title of possession was sufficient to maintain an action only in certain cases. It was considered sufficient to allege possession as against a wrongdoer, or, in other words, that it was enough to lay a title of possession against a person who is stated to have committed an injury to such possession, having as far as it appears, no title in himself. Such a title may support an action for obstructing a right of way, and in many instances of the possessory right of personalty. With references to the rule requiring in some cases derivation of title to be set forth, not much need be stated. It was not essential to show derivation of title if it be a sais in fee simple. But in cases of particular estates the rule was that the commencement thereof had to be shown. If, therefore, a party set up in his own favour an estate tail, an estate for life, a term of years, or a tenancy at will, he had to show the derivation of that title from its commencement, that is, from the last sais in fee simple, and if derived by alienation or conveyance, the substance and effect of such conveyance had to be set forth. If he claimed by inheritance he had to show how he was heir, and in some instances the pedigree had to be shown. If the claim was by way of conveyance or alienation, the nature of the conveyance or alienation had to be stated. But the nature thereof was stated according to its legal effect rather than by its form of words. In code practice title to real estate may be set forth in the form of a conclusion, by merely stating that the party is the owner. No derainement of title is ever necessary. Sec. 158. Evidence should not be stated in the pleading. It was improper at common law, as it is under the code in alleging a fact, to state such circumstances as merely tend to prove the truth of the fact. This rule was elementary, Stephen states, and so well observed in practice as not to have become frequently the subject of illustration by decided cases, that it was a rule of great importance, from the influence which it had on the general character of English pleading, that it was this, perhaps more than any other principle of the science, which tended to prevent that minuteness and prolixity of detail in which the allegations, under other systems of judicature, were involved. The ultimate facts, those deduced from the evidence, are what is to be stated in the pleading. Sec. 159. Matters of which courts take judicial notice. It was unnecessary to state matters of law, for this the judges are bound to know, and can apply for themselves, to the facts alleged. This is the rule under the code. This rule does not alone forbid the statement in a pleading of the principles of the common law, but makes it unnecessary and improper to plead the provisions of public statute law. It was otherwise as to private acts of parliament which the courts do not officially notice. If a party has occasion to rely upon an act of that description he must set forth such parts of it as are material. Sec. 160. Matters which would come more properly from the other side. This relates to anticipating the defense which was improper under the old system of pleading as well as the new. It is sufficient that each pleading in itself contain a good prima facie case, without reference to possible objections not yet urged. It was a part of equity pleading however to anticipate in the bill what excuse or defense the defendant would make and allege facts showing the same to be groundless. Now that the two systems are united in one, and the same rules of pleading, so far as the intrinsic nature of each subject will permit, apply, the rule forbidding the anticipation of a defense applies under the code, to both actions in law and equity. Anticipating the answer of the adversary according to Hale, c. J is like leaping before one comes to the stile. If the matter is such that its affirmation or denial is essential to the apparent or prima facie right of the party pleading, then it ought to be affirmed or denied by him in the first instance, though it may be such as would otherwise properly form the subject of objection on the other side. An exception to this rule was made in the case of certain pleas which were regarded unfavorably by the courts as having the effect of excluding the truth. The plea of estoppel was given as an example. As to this and certain others, it was said that they must be certain in every particular, which rule was to the effect that they must meet and remove, by anticipation, every possible answer of the adversary. If, for example, if the statement of the cause would disclose facts from which the inference of estoppel might be drawn, this should be removed by anticipating facts. So now for example further, if in the statement of a cause for negligence it should appear that plaintiff himself might have been negligent, some facts should be stated to remove that inference, and show that the proximate cause was the negligence of the defendant. So if it should appear that a claim sued on is barred by the statutes of limitation, some facts to relieve that bar must be stated. Sec. 161. Facts which will be implied or presumed should not be pleaded. It is not necessary to allege circumstances necessarily implied. Expressio erumque tacit insant nihil operata. The expression of those things which are therein implied has no force. If a man plead that he is heir to A, he need not allege that A is dead, for it is implied. It is not necessary to allege what the law will presume. The law presumes that a man's reputation is good, so that in an action for slander or libel, he need not aver that it is good. The rule as to implied allegations is the same in code and common law. So as to presumptions, it is a simple logical rule that the allegation of a fact from which the other fact must follow is to be regarded as a sufficient allegation of the latter. Sec. 162. Less particularity is required when the facts lie more in the knowledge of the opposite party than of the party pleading. This is a rule common to both systems. Sec. 163. Other rules. Some of the following rules of pleading, here only briefly stated, are familiar rules common to both systems of pleading. 1. A general mode of pleading is allowed where great prolixity is thereby avoided. This was an important rule pleading under the common law, and still holds good in code practice. Stephen said that it had been objected, with truth, that it was indefinite in form, and was content to exemplify its extent and application with some degree of precision from the examples by which it was illustrated. In Chitty's Pleading, 235, as cited by Perkins, J. In State v. McCormack, 2 Indiana, 305, it is stated that, in civil cases, it is a rule that where a subject comprehends multiplicity of matters, and a great variety of facts, there, in order to avoid prolixity, the law allows general pleading. 141 Indiana, 267, 54 AM. Street, 320. 2. A general mode of pleading is often sufficient where the allegation on the other side must reduce the matter to certainty. The rule comes into most frequent illustration in pleading performances in actions of debt on bond. The bond may be conditioned according to its own terms or provisions, as well as upon other covenants or matters contained in a separate and independent indenture which is collateral to the bond, and which are not set forth in it. In either case, if the defendant has to plead performance of such matters, the law allows him to make such allegations in general terms, without setting forth the manner of performance. By the usual course of pleading, the plaintiff declares upon the bond as single, without noticing the condition, and without alleging any breach of condition. If the defendant pleads performance, the plaintiff shown a breach in the replication. It was unnecessary for the defendant to be more specific on his part in his plea, or to do more than allege performance in general terms, according to the words of the condition, leaving the plaintiff in his replication to specify the breach. This generality of pleading was only allowed where the subject comprehends multiplicity of matters. But this mode of pleading was improper where the covenants in the collateral instrument were either in the negative or the disjunctive form, in which case the allegation of performance had to be more specifically made. The reason for this rule was that the plea would be indirect or argumentative, or equivocal. In code pleading, the performance of conditions need only be alleged in general terms by either party. 3. No greater particularity is required than the nature of the thing pleaded will conveniently admit. This rule was applied in actions for injury to goods where quantity had to be stated. If it could not be conveniently ascertained, by number, weight or measure, such certainty was not required. So in trespass by breaking plaintiffs close by beasts, the declaration not showing the quantity of peas consumed by beasts held sufficient. These illustrations do not reflect upon the propriety of the rule, but upon the senselessness of other rules of certainty. The rule that no greater particularity is required than the nature of the thing pleaded will conveniently admit is as efficacious as ever, and may be resorted to in many instances under the code where the particularity of allegation is called in question by motion. 4. Less particularity is necessary in the statement of matter of inducement and aggravation. Matter of inducement is matter introductory and leading up to the cause of action. Matters leading up to a contract will not render a complaint ambiguous, uncertain or unintelligible. The rule is exemplified in the matter of derivation of title, where, though the rule is that the commencement of the particular estate must be shown, yet an exception is allowed if the title be alleged by way of inducement only. While the introductory matter stated by way of inducement in code procedure may not assume the same position as in common law practice, it is clear that the statement of matter leading up to the cause of action sometimes plays an important part in the assertion of the cause of action. This common law rule does not obtain in its full force and effect in code practice. 5. With respect to acts valid at common law but regulated as to the mode of performance by statute, it is sufficient to use such certainty of allegation as was sufficient before the statute. This rule has reference to acts which come within the operation of the statute of frauds. In an action upon a promise to answer for the debt, default or miscarriage of another, which was good by parole at common law, but made invalid by statute, it was not necessary that the declaration on such promise should aver that there was a written contract. The complainant declares upon the promise as if it were made and executed in the manner provided by the statute, as if it was presumed that it was in accordance with the statute. The code has followed and adopted this rule. There was a distinction, however, between a declaration and a plea as to the operation of this rule. While the declaration need not show the thing to be in writing, still it was essential that the defendant must so show. The rule was that when the defendant pleads such an agreement in bar, he must plead it so as it may appear to the court that an action will lie upon it, for he shall not take away the plaintiff's present action and not give him another upon the agreement pleaded. Stephen P. L. 429-30. The same rules as to this matter prevail under the code, not by virtue of any statute, but by general acquiescence in common law doctrines. 5 1/2. Pleadings must not be insensible nor repugnant. If a pleading be unintelligible, or insensible by the omission of material words, the pleading was vitiated. If it was inconsistent with itself, or repugnant, it was subjected error. This rule might have application to either plaintiff's or defendant's pleading. The present statutory rule of the code that a defendant may set forth as many defenses as he may have, so long as they are consistent with each other, is but an embodiment of the statute of Anne, allowing a defendant to plead as many matters of fact by way of defense as he saw fit. If a pleading was not consistent with itself, it was subjected error. The several pleas which might be set up in the plea under authority of statute had to be consistent with each other, and such is the rule now. 6. Pleadings must not be ambiguous or doubtful in meaning, and when two different meanings present themselves, that construction shall be adopted which is most unfavorable to the party pleading. This rule was founded upon the rule of construction that the pleading was to be construed strictly against the pleader. Chitty stated the rule that the language of the pleading is to have a reasonable intendment and construction, and where an expression is capable of different meanings, that shall be taken which will support the pleading. 1 ch. Pl. 237. 7. Degree of certainty required. A pleading was not regarded as objectionable, as ambiguous or obscure, if it was certain to a common intent, that is, if it be clear enough according to reasonable intendment or construction, though not worded with absolute precision. 8. The negative pregnant. A negative pregnant is such a form of negative expression as may imply or carry within it an affirmative. In other words, a denial in the precise language of the allegation. The reason why this is considered as a fault in pleading is that the meaning of such a form of pleading is ambiguous. In the later common law procedure, the rule against this evil did not receive a very strict construction, many cases occurring where that form of expression upon various grounds of distinction was held free from objection. 9. Pleadings must not be argumentative. The requirement is that pleadings must present their positions in absolute definite form, and not leave them to be collected by inference and argument only. This is the rule under the Code. 10. Two affirmatives do not make a good issue. The reason for this rule is that the traverse by the second affirmative is argumentative in its nature. If it becomes expedient for a party traversing to set forth new affirmative matter, tending to explain or qualify his denial, he is allowed to do so. As this standing alone renders his pleading argumentative, he is required to add to his affirmative allegation an express denial, which is held to cure or prevent argumentativeness. The doctrine is not taken so strictly but that the issue will in some cases be good, if there is sufficient negative and affirmative in effect, though in form of words there be a double affirmative. This rule holds good under the Code. 11. Two negatives. Another branch of the rule against argumentativeness is that two negatives do not make a good issue. This is still the rule. 12. Pleadings must not be in the alternative. This rule was applied strictly to a defendant confining him to a definite position. In an action for debt against a jailer for the escape of a prisoner, it was ruled that defendant could not plead that if the prisoner escaped, he so escaped without his knowledge, and that if he escaped the prisoner voluntarily returned, for he cannot plead hypothetically that if there has been an escape there has also been a return. He must either stand upon an averment that there has been no escape, or that there have been 1, 2 or 10 escapes, after which the prisoner was returned. Alternative pleading is sometimes allowed under the Code. 13. Pleadings must not be by way of recital, but must be positive in form. The rule is the same in code procedure. 14. Things are to be pleaded according to their legal effect or operation. The subject of legal conclusions has been considered. Stephen states that the meaning of this rule is that in stating an instrument or other matter in pleading, it should be set forth, not according to its terms or its form, but according to its effect in law. The reason assigned for the rule is that it must be principally and ultimately so considered, and, therefore, to plead it in term of form only is an indirect and circuitous method of allegation. The rule was often confined to deeds and conveyances. It extended also to all instruments in writing, and contracts, written or verbal. And, indeed, says Stephen, it may be said, generally, to apply to all matters or transactions whatever which a party may have occasion to allege in pleading, and in which the form is distinguishable from the legal effect. This statement of Stephen appears to be in conflict with the well-settled common law rule forbidding pleading legal conclusions. It was regarded as proper to plead written contracts according to their legal effect, and it is still so considered in code practice. 15. Pleadings should observe the known and ancient forms of expression, as contained in approved precedents. This is no longer so. 16. Pleadings should have their proper formal commencements and conclusions. This is one of the discarded ideas. 17. A pleading which is bad in part is bad altogether, of no practical application under the Code. 18. There must be no departure in pleading. A departure takes place when, in any pleading, the party deserts the ground that he took in his last antecedent pleading and resorts to another. This is still the rule. It is the settled doctrine that a cause of action must rest upon a definite theory, which must not be departed from in any subsequent pleading. A departure cannot take place till the replication. It may occur in the rejoinder or surrebuttal. The rule is to prevent the retardation of the issue, but more especially to prevent parties from shifting their ground of action as often as they pleased, and an almost indefinite length of altercation. 19. Where a plea amounts to the general issue it should be so pleaded. The meaning of this rule is that if, instead of traversing the declaration by the general issue, the defendant pleads in a more special way matter which is constructively and in effect the same as the general issue, such plea will be bad. and the general issue ought to be substituted. This rule obtains now as applicable to the general denial. 20. Surplusage is to be avoided. Surplusage is taken to mean unnecessary matter of whatever description, utile, per inutile non visita. That which is serviceable is not rendered invalid by what is useless. To combine with the requisite certainty and precision the greatest possible brevity is considered as the perfection of pleading. This principle, however, was very well followed. Surplusage could not be remedied by demurrer. In some instances the pleadings were referred to a master that he might strike out such matter as redundant. 21. The declaration should commence with a recital of the original writ, of no consequence now. 22. The declaration should, in conclusion, lay damages, and allege production of suit. 23. Pleas must be pleaded with defense. Defense signifies a certain form of words by which the plea is introduced. Thus used it did not of its popular meaning. It imparts denial, being derived from the law Latin defendia. The effect was to deny the right of the plaintiff, but the denial was a mere matter of form, being used not only by way of denial but when the plea is by way of confession and avoidance also. 24. All affirmative pleadings which do not conclude to the contrary must conclude with a verification. The form of so-called verification was, and this the said AB is ready to verify. There was no affidavit to pleadings as under the Code. 25. In all pleadings where a deed is alleged, under which the party claims or justifies, profit of such deed must be made. The statement was made, that the party brings the indenture into court. 26. All pleadings ought to be true. This was a requirement in the common law, but as there was no means of enforcing it as a rule of pleading, it amounted to but very little. Sec. 164. Variance. A variance is a disagreement between the proof and the allegations. The established common law rule was, that when the disagreement between the proof and allegation was upon a material point, it was fatal to the party on whom proof rested as a total failure of evidence. It was necessary to state a contract correctly, and if the evidence differ from the statement, the whole foundation of the action fails, because the contract is entire in its nature, and must be proved as laid. A misdescription of the parties to a contract, and with whom it was made, caused a fatal variance. And so with a misstatement of the date of a written instrument, or as to the time of performing a contract. 8066 Such matters under the Code are deemed immaterial, and may be cured.